not contend that there had been earlier completed coalitions in respect of Nsawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi Kwete dated.
You want to call one more studios. With the breaking news, ACC a sheshe na aba. NDC for the Assembly Cordon Supreme Court. Efa recoalition a High Court judge a grantema yisi emo mkoyewo sa constituency 7 NPP for union. And NDC for the Supreme Court na Supreme Court for Edwom ruling aba. Na ruling mu enchechere mu ni. The din kan NDC for the court say High Court judge no asem na odi no wanhwe NDC for parliamentarians no ewosenka omo ka se omo so wasem ka be wanti na no ni tia natural law na natural law no kire se wonu obi nya asem a ewo so ma no ho kwan no so kire na adwene nti judge no High Court judge no amo omo kwan amo omo so ankire omo adwene eno no Supreme Court ebuoti ase wanye ni ne nko so omo kwan omo kire omo adwene ti Supreme Court nhwehwe ye no sa constituency no emu mienu de Supreme Court age atum sa recoalition no ye no age atum se ejina honum pintin a o monsesa no eno no ne Nsawam Adwajiri na Ahafwano North na di nti ogitum ni se sa afo no anodompre omo no de datom ye coalition constituency no mu gina ka se no coalition no mu munya wi nto mo nye resource ne ade ni ntum to mo no de ende ejina opintin na ye for bi aka na Supreme Court ahye se omo de ende omo nyi ntum wo se omo ko High Court foforo ekope judge foforo na judge atena sa asem no so na wa hye se NDC for no so a omo parliamentarians no omo kwan so omo nyom documentum bibia ready no omo fa nko no omo so ne yinti omo asem na judge no Supreme Court ahye se omo until 31st of December say ombeka sa asem because election matters no was say omudi ni intentem na sa for constituency no any Ablukumanov Okankwi Central Tema Central na Techiman South sa constituency ni ya hye se omo sa fa asem no ko High Court bi na judge foforo nye de be entena so wa hye wo say by 31st of December was omo kasa asem ni wi na wo kire say High Court judge no asem no de bae no sa direction de ma yisi ni de da so gina ho say yisi nkoye coalition no na omo kwan so omo ko ka omo asem na ebusuafo de Supreme Court for de abani NPP for seats no omo gi ye emu 9 ya sa omo direction say omo ko ye nemeyi ti ya ma ho kwan say NDC for omo from High Court on form documents ni ade mra na omo nsanye na omo wie yisi nkugina so na onye coalition for ne mu mienu de da so gina hono say ende de omo wie Nsawam Adwajiri na Ahafwano South da masese muti mun subscribe na mun share my this is my first studios. Thank you.
Yes. In this case, none of that happened. So the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okankwi Central. 2. Ablekuma North. 3. Tema Central, and 4, Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Hafuanon North are not affected by this order, by this our order, and in effect, those declarations stand. Despite questioning the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed, yeah. Now those which have been quashed, sorry. Those which have been quashed, yes. To file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court, ex parte, Ajua Company Limited, Auditor General, Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.